that contract of sale which you are entering into. Now we are going to begin as usual with a very short story. Today we have in our story Tife Osamu and Okojibola. Now Tife Osamu is a landowner who intends to sell a portion of her land, and Okojibola has also indicated interest in purchasing that land, but they are unsure as to the roles and other duties they owe to each other than to just sign the document of transfer and pay the purchase sum. What are other things that they owe to each other in regards to this land transaction they are entering into? That's what will be that's the basis of today's discussion. So that summarizes the need for today's topic. So we'll be discussing those covenants you need to include in your contract of sale. Now, in every contract of sale, there must be covenant which reflects the role each party is expected to perform for the successful execution of the contract. Now, the contract of sale of land does not end at just appending your signature in relevant pages in the contract of sale, or just payments of the purchase price. There are certain things that are required from the vendor, and there are others that are also required of the purchaser. One thing that people have come to terms with is that, okay, the major thing that the purchaser has to do is to pay the purchase price. No, his responsibility does not end there. There are some covenants that he is expected to adhere to, not just only payment of the purchase price. Now, what are the things that he needs to do as the purchaser? What are the things that he must observe for him to enjoy that property which he intends or must have already purchased from the vendor? First is to pay the consideration, that is the purchase price of the property. For you to enjoy any property which you intend to acquire, you must first of all pay the purchase price. Without the payment of the purchase price, which is the bedrock upon which you stand on any transaction which concerns purchase of land, you must ensure that you pay the purchase price. In every contract of sale, it is important you include the payment of purchase price. That is the first responsibility the purchaser has in every contract of sale. Failure to pay this purchase price renders every other rights that he has under the contract unenforceable. So if you want to be in a position where you can enforce the rights that are contained in the contract of sale, you must, as a purchaser, ensure you pay the purchase price of the property. Now, when you fail to pay this purchase price, the vendor can repudiate the contract at any time. It doesn't matter how long the contract has been in existence, whether 10 years or even 20 years. As long as you have failed to adhere to this covenant to pay the purchase price, not just pay it a specified time within which you have to pay the purchase price. If because of the payment schedule you included in the payment, then maybe it gives you a 5 years payment plan. It doesn't mean that after 5 years you still keep dragging it. Once it's past 5 years, let's say 6 years, or even 5 years and a day, the vendor can decide to repudiate the contract. That is, he can decide to withdraw from the contract, and there is nothing you can do, because the court cannot help you when you have failed to perform your own part of the contract. This is why this particular covenant is important to the vendor when you are drafting contract or sale of land. Then another thing that you may also want to include is payments of all costs incidental to preparation of the landed documents, titles to the land. Now, the actual procedure is that when it comes to payments for the draft or preparation of contract of sale, it is the landowner or the vendor that ought to pay the legal practitioner that is going to prepare the contract or sale, because he has more interest in the land than the purchaser. The only thing the purchaser has at this instance is his money that he's going to part with, but the vendor has more interest to protect the land and some other ancillary interest that comes with ownership of land. So the vendor is expected to have his own lawyer to prepare a contract or sale. However, what is practiced today is the vendor who is unwilling to expend any money from what he's going to get from the purchaser usually asks the purchaser to get a lawyer to prepare these documents. Now, if you are going to get a lawyer to prepare this document as a purchaser, it should be stated there who is making payments. We have seen that most times the purchaser is one who pays the legal practitioner who prepares the documents. Now, if it is the purchaser that is going to prepare the purchaser's lawyer that is going to prepare these documents, it should be stated there clearly that he will be the one responsible for the payment of the cost of legal documentation, that is contract of sale and other documents that may be required for processing of title. That's one thing you need to include in the contract or sale, so as to ward off any cost to you as the vendor. Another one you may want to add there is restrictive covenants. As you know, there are some restrictions that are running with a particular land. Let's say, for instance, a particular region or location has been designated for agricultural purpose. Whoever is coming to that place to purchase a land must use that land for agricultural purpose only. Now, when you are drafting a contract or sale, you must ensure that you insert this particular covenant, which ensures that whatever the purchaser is going to do with the land falls in line with what the land was originally designated for. Let's say, for instance, a particular plot of land is designated for agricultural purpose, and the sole purpose within that same agricultural sector is, let's say, cocoa plantation or rubber plantation. If you insert this restrictive covenant, it will prevent the purchaser from using that particular plot of land for any other agricultural purpose other than that which was specifically stated. So you must ensure you state that the purpose of the purchase must be in line with that which the original owner used it for. So failure to adhere to this covenant, the government, if they have already issued title documents, they can revoke that title document which they have issued to the person. So as a vendor, you must ensure that this particular covenant is inserted to prevent you from incurring any loss. Tomorrow the purchaser may decide to come to you that, okay, the land which he purchased from you has been taken from him by the government. But if you have this covenant inserted in the contract of sale, when it comes up to say the land has been revoked, then you can cite this particular covenant which stated that he must use that land for this purpose, and failure on his part to use the land is no longer your own business. Then you have no duty to him under the contract of sale. Now, what about the vendor? Does he owe any duty to the purchaser other than just signing the title documents which will be prepared by his lawyer or the purchaser's lawyer? We are going to be looking at what he also owes to the purchaser in this regard. Now, the first thing there is to provide all necessary documents for due diligence purposes. Now, before you go on to purchase a property, there are preliminary search you have to conduct. You conduct due diligence on the property. You may not be able to conclude everything before you go on to sign this contract or sale. Now, the person must undertake that he will provide all necessary documents. Let's say, for instance, the property was gotten via assent, that is, the person received it from will that maybe the spouse, the parent, or someone gave him the property through a will, and it was through assent. Now, if the person has gotten assent and he has cited different documents that, okay, this is how I got the property, but you have not been able to complete your due diligence, you also insert this covenant as a purchaser that the party who is selling must give you all necessary documents for you to conclude due diligence. To adhere to this, you can always repudiate the contract for failure to provide the necessary documents for due diligence on the property. Now, covenant to assist the purchaser in registration process. It is also important to insert this clause. Other than just providing documents, it should also be stated that the vendor should be available at any point in time that he may be called upon for the purpose of registration. However, it should be stated there that the vendor being present will not attract any cost to him. Now, if you are going to register a property as a purchaser, the vendor is not the one to pay for any registration fees that will be required of you by the government. However, he can be there, or he should be there, to assist you, providing all necessary information. Now, there are instances where they may need to do further search on the property other than the information that has already been provided. You need a letter of authority and all of that from the vendor. Now, if this is the case, he is to undertake that he will be available at every point in time. You will be needing his assistance to complete the registration of the property. That's another thing you need to ensure it is stated there. Then another covenant is that the vendor covenants that he has the capacity and authority to enter the transaction. Now, there are some persons, they may have the capacity, they have age, so they can transact when it comes to land. They may not have the authority to sell that particular land. They may be in possession, that's quite right. Now, there are instances where a particular property belongs to a family. And if a property belongs to the family, the person must have the consent of other members of the family before he can sell that property. Also, let's say the person is also a trustee. He needs the consent of those he's holding that property in trust for to transact on that property. He cannot just go out there because he has been entrusted with the property, therefore he can do whatever he wants with the property. He must show that he has the consent and authority of the persons who are interested in the land before he can transact in that in their stead. That's one thing you must ensure it is contained in the contract of sale. You must state that he has the rights to transfer the title, not just in his own behalf, but on behalf of other persons who have interest in the land. Now, the general covenant that should be there is both parties have rights to enter into, or they have the capacity to enter into the contract of sale. When they do not have the capacity, or any of the parties does not have the capacity, it means therefore that contract is void ab initio. Let's say, for instance, a purchaser who is underage, he decides to enter into the contract of purchase of land. That is a luxury. It's only when the thing that is being purchased is a necessity, that is when such contract can bind a minor. If the person is not of age, therefore he does not have the capacity either to sell or to purchase any landed property in Nigeria. So you must ensure that this covenant is there, that the purchaser warrants that he has the capacity to purchase, and the vendor warrants that he has the capacity to also sell. When you put these two together, it gives the contract of sale a life of its own that each party can be held responsible for. Now, in summary, when you are dealing with covenants in contract of sale, it represents the undertakings, that which each party has said, okay, I have agreed to perform under the contract of sale. It is not enough for you as a purchaser to just transfer whatever sum that we agreed by parties without making sure that what is required of the other party is properly documented. Without proper documentation, without defined rules of each party to a contract of sale, they can easily withdraw to say, it wasn't stated there that I have this role to play. I have signed the document. Whatever troubles you are facing, that is no longer my problem. I have done all what is required of me under the covenant. So you must ensure that all these covenants are clearly stated in the contract of sale for you to be sufficiently protected. Thank you. This is how far we can go today, and we hope to see you next week, where we will be discussing another interesting topic. And follow us on all our social media platforms for you to learn other things that are going on in the system. Thank you very much for your time.
Today, 30 minutes. Hey,
Record breaking.
I think I'm loving this.